The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, and I hope everyone who's been invited is listening in now. I'm Thalis, Vlachos. I'm an employment law partner here at gunnercooke, and I like these sessions to be interactive because, from my perspective, I'm just looking at a screen. So it'd be nice if you have any questions. Please feel free to email me those questions, and I'll address those questions as we go along. It just makes it much more interesting for everyone. Now, the title itself is pretty ambitious. How do you make litigation commercially attractive? And how can you make it more certain for your clients? Now, this isn't rocket science, and there's some certain rules you need to follow. You need to manage the risk. Now, how you manage the risk is you make sure that commercially you organise the funding for your clients. So you've got to organise a budget. Also, you've got to organise a contingency. So if one strategy doesn't work out, you've got a plan B so that you can move on to that plan B. And also, within that strategy, you've got to have the tactics that you're going to engage in, that you're going to employ. So, and you'll see this in the case examples that I give you. It's all very well engaging and employing a solicitor who's technically gifted. But if that solicitor doesn't have some commercial packages in place where they share the risk of litigations and the spoil of success, or at least in the first instance put forward some insurance funding if you're an employer, then you're really thinking as you're going along and you're allocating funds to that solicitor without knowing what the end game is going to be. So what you really want out of your lawyer is for them to give you their full-blown opinion, for them to give you a strategy, for them to give you tactics on how to implement that strategy, and to correctly budget for the actual case itself. Now, in my view, going to court and attending the court hearing means that the parties have failed. Now, sometimes there's nothing further you can do. It takes two to tango, and if the other party doesn't want to come to the negotiating table, then you need to have your contingency plan and you need to proceed to litigate. Now, in my view, the good litigator, and the litigation is an art form, and I do believe that it's not just a question of being a technically gifted lawyer. They need to see and consider what pressure points they will place on the other side to ultimately bring them to the table. I mean, most of the cases that I litigate on or I negotiate on do end up with a final negotiated settlement. And that's not because so much we're scared to litigate, but we can commit to the litigation if we actually need to. So, for example, if you're acting for an employee in any litigation, no one is really that concerned about what's happened to that employee to actually promote a settlement. What they're more concerned about is, in the public interest, what is their reputational damage going to be. And I will go over this in the case examples that I present to you. So you look at the individual case, you look at what the allegations are and whether you can sustain or plausibly put forward contentions on those allegations, but also you look at what reputational issues are attached to that case or on a wider scope, so you can exert pressure on the other side to consider going to the negotiating table. Also, you need to make sure in many ways that you're going to create a lot of commercial time for them to further promote them coming to that negotiating table. And if you're acting for an employer and you want to promote an early settlement in some instances, and you don't want to give significant disclosure, you drip feed information. If you're acting for an employee, you press for discovery, for disclosure. And I will give you more examples of this when we look at actual sort of case studies, which are actually based on cases that I've advised on and I've litigated on. Now, the main point is and you'll see this in the cases that I talk about, is to organise the funding. So you're front loading everything. If you act for employers, in my view, you've got a duty to organise insurance for them and make sure that they've got legal expense insurance funding in place so that if there are any issues with any employees, they are then in a position to litigate. And it's not rocket science, it's very simple. We attend, we look at the contracts of employment, we look at the staff manual, we confirm that you're all up to date on that, and then we organise insurance through a broker. And you'd be surprised how cheap this insurance actually is. Obviously, if there are public listed companies who are listening in on this webinar, it may not apply to them. But certainly if you're a company with a certain level of employees or certain amounts of employees, you should certainly have that in place. And also have your lawyer working in conjunction with an HR person to create maximum cost efficiency on that. So you've got that cover. Now, I've got clients of mine who didn't listen to me on that and having to then pay me my hourly rate, which I would normally negotiate with the insurers. And you send various messages out. And I can give you, and I will give you sort of a case example of what strategy we used in that case, but unfortunately, good job it worked, because the small to medium-sized enterprise in this instance didn't have insurance-backed litigation support. Also, if you're an employee, I've got a situation where, and this is another case example I'll provide, I specifically informed this long-standing client of mine, get legal expense insurance. It costs you, I think, £20 a year on your home and contents. He ended up in litigation with his employers, and that's another case example that I will provide. And although we did very well at the end, and we did do very well because we used a very good strategy, it did create a lot of issues for them because we had to then organise after the event insurance. And as a last resort, you've still got the after the event insurance which you can possibly use, and use that to promote a settlement with the other party. Now, what is my job as a litigator? Now, what we do is we need to provide a substantive opinion right from the get-go. So I had a client of mine recently who said to me, look, Thalis, this case seems pretty simple to me. Can you please just send out 2 letters and get those letters out, and let's see whether or not we can do the deal. Now, I pointed out to the client that if that's what you want out of your lawyer, I'm not the right lawyer for you, so you need to go elsewhere. Now, getting a proper, full-blown opinion in terms of prospects, in terms of what aspects of your case are strong, what aspects of your case are weak, how much is it going to cost, what are the potential implications of going to litigation if you are an employee? What is the value of the claim? And what are the possible packages in place that you can use to assist in the litigation, i.e. legal expense insurance, some form of contingency fee agreement, and also some form of after the event insurance? You've got that all covered within a fixed fee. And then the case almost runs itself. It's less stressful for the client, less stressful for the lawyer. We can all sleep at night, and we're not thinking as we go along, which unfortunately sometimes happens in litigation, and it shouldn't. And also, the objective is, how do we bring those parties to the table to negotiate? What do we utilise to bring them to the table to avoid having to go to a court hearing? Now, once the strategy is agreed, my job is to drive that case. I need to drive that case to conclusion. That's my job. So I need to chase my client, I need to chase the other side. And that will, most of the time, promote a settlement. However, what happens if the case doesn't settle? There's one thing I learned as a litigator, and it's the same as a basic principle as when you're buying a house. Not when you're buying a house, when you're selling a house. If you're selling a house and you've got 2 buyers, you've got leverage. If you're selling a house and you only got 1 buyer, you don't have any leverage. Now, in this instance, what you need to do is have a contingency plan if plan A doesn't work. And most of the time, that contingency plan has to be a commitment to litigate. I was discussing this with one of my colleagues yesterday, and they pointed out to me, Thalis, unless you go to court or you're 1 or 2 days before a hearing, you're not going to maximise your claim, or you're not going to get the best defence you possibly can, and you may pay out more than you need to. Now, I agree to a certain degree on that, but the flip side of that is if you show to the other side that you've got a commitment to litigate, which you need to have. No one negotiates and says, look, all parties want to be amicable here, we don't want to go to litigation. Say, no, we will go to litigation if we can't come up with some form of a reasonable settlement solution. Then you've got to have a contingency in place. Now, the only way you're going to have that contingency in place is if you've got funding. I can't advise my client, and I'm going to give you some examples in terms of lawyers who have advised their clients to litigate and the context and background to that advice, which forced them not to be able to use that lawyer. You've got to have some kind of financial arrangement in place with your client before you commence the process. So you've got to have front-loaded your whole case, prospects, strategy, tactics, budget, cost funding. All that needs to be in place, in my view, even before you pick up the phone to the other side. And that is whether or not you're putting a claim in or whether or not you are putting in a defence. Now, I'm going to give you some case examples, which as I've said, are based on real-life cases. Now, some of these cases are where I've acted on behalf of senior executives. Now, employers may say, well, how is that going to be relevant for me? Well, it's going to be relevant because you'll see the flip side of how a litigator would act when they're acting against you. So if you get a little bit of insight here, you'll see how you can foresee some of the arguments that they will use or some of the tactics and strategy that they will use so you can avoid that. And you can give appropriate instructions either to your senior managers or you give appropriate instructions to your internal HR or anyone in charge of your codes of practice and your staff manuals. Now, I will also, and also you'll see there is a completely different strategy when you're acting on behalf of individuals and when you're acting on behalf of employers. When you act on behalf of individuals, you press for information. That's what you do. That's your strategy. You need to embarrass the other side. You need to affect their reputation. You need to ensure that they spend a lot of commercial time having to deal with your client. And also you need to ensure that you're credible. You've done your homework. You know what questions to ask. You know what tactics to adopt. And they know that they're in for the long haul. And some cases, you know you're in for the long haul. Some cases you can settle at an earlier stage. Acting on behalf of employers, very interesting. Strategy will be, obviously, you need to have everything in place. So hopefully you've got your insurance in place. Hopefully you've got your good lawyer on call. Hopefully you've got your internal HR who has been advising you in conjunction with your lawyer and has given you a detailed opinion. But in the employer's case, they get pressed for information. Employers will be drip feeding information. Drip, drip, drip. They can't give anything. They've got to drip feed because then there'll be some certain milestones where they can reach some form of negotiated settlement, and also don't want to expose too much what they have done. What we'll also see during the course of this webinar is really lessons that we can learn if we are the ones who are litigating and what we actually need to do, what employers need to learn. And again, it's not rocket science. is making sure that you have all your ducks in a row right from the start. Also, closing the deal. Milestones for settlement. There will always be milestones when there's an opportunity for parties to settle. The first milestone will be the initial letter from the solicitor, or it'll be a letter before claim. If it's an employee, it will then be after a grievance has been submitted. Then on an outcome of the appeal. If you can't do a deal at that stage, it will have to be after proceedings are issued and a defence has been claimed, has been filed, or just before a case management hearing or some form of preliminary hearing. In my experience, if we haven't settled at that stage, or soon after, you're looking at settling close to trial, and that can cause a lot of stress for your clients. And we'll also look at is prevention, and sounds cliche, is better than cure. Make sure you've got everything in order, make sure you've got your legal team in order, make sure you advise your employees on appropriate codes of conduct, equal opportunities, your managers are aware of that, you've got insurance to back up if the claims are made, and you can avoid any litigation. Of course, we've got appraisal systems and all the rest of it and openness, but that's beyond the scope of the webinar for today. Now, on to some cases. Now, this is one case that I knew was going to drag on for a long period of time, and it's sort of pretty sad. I mean, this was a case where we were claiming associative disability discrimination, and in this instance I was acting for a senior executive, a senior account handler, in probably one of or the largest global media company, if I can qualify it, in the world. And in this instance, unfortunately, her husband, who was been very, very successful in business, was dying from cancer. He was terminally ill. And she couldn't allocate the time that she could previously at the office because she had to look after her husband. And the issue here was that her line manager wasn't happy about that. And slowly but surely, she was taking away aspects of her responsibility, allocating those responsibilities to more junior people in the organisation, and also picking on various aspects in terms of how she was performing her job role. She came to see me about 2 years ago and said, look, I'm being performance management. I think they're looking to get rid of me. And what happened in this instance, I advised her and I said, look, this is not going to get any better. It's actually going to get worse. You know, it doesn't matter how much you discuss things with your line manager, it's going to ultimately look like some form of exit at the end. But this was going to be a long-term strategy. So what we did in this case, we took the whole case apart and we gave a substantive detailed opinion in terms of prospects and what she was likely to get at the end. Yeah, she ended up getting a lot more. But what was fundamental in this case, and how it's relevant to this title, is she had legal expenses insurance and she maintained that. So when she came to see me, about June 2015, even possibly before, she had legal expense insurance in place. So we had a war fund if we then had to litigate against her employers. Lo and behold, trigger point in 6 months later, where she was too ill to continue working, so she went on sick. But she was being paid full pay during that period of time. And we then filed a very detailed grievance. This was a grievance with about 30 to 50 pages and about 100 pages of attachments. So what we did, we turned this into a quasi-judicial court. So we prepped it up as if we're going to a hearing. And we pressed hard for disclosure and discovery. Now, there are a few challenges on this case. The one challenge was that this was a major institution. Now, if my client didn't have her own legal expense insurance, she would have needed £100,000 to £150,000 to litigate. So we needed to have that. Also, they were well known to be pretty aggressive. So I knew that by just picking up the phone and really with the amount of money that we were asking for, we weren't going to get this deal done in a couple of months or even in 6 months. We had to see this through. And so these were the challenges that we were facing. So we filed a detailed grievance. Within that grievance, we put in detailed requests for disclosure. And as we put in those detailed requests for disclosure, other things came up and other issues came up in terms of them failing to provide information to us, showing that HR themselves had misrepresented some of the facts because those facts did not communicate with the subsequent documents that we obtained. So this was all part of our strategy. Press on disclosure, get further information, provide real detail and cross-reference what their code of practice said in terms of how they treat employees with how they treated employees, and being a business which promotes itself on good family viewing, showing how they behave towards our clients. And that put them under a lot of pressure. And what put them even under more pressure was the fact that their own HR had misrepresented the facts. And we really closed in on that. Now, the big issue here was we couldn't get a deal done internally. So we then had to go through legal expense insurance. Now, again, this is where you need a lawyer who's going to be challenging, because if you've got legal expense insurance, you've got a number of hurdles that you need to get over. The first hurdle is the fact that you've got to have reasonable prospects in the case itself. And in this instance, they used their counsel, the insurers, and said, my client didn't have reasonable prospects on a case that was, in fairness, pretty complex. But they should have given funding on it. What we had to do was get our external counsel to confirm prospects. That took some time, and we got it done. Then the insurers refused to pay my hourly rate, which means I would have had to have got the balance from my client. So if they're only paying £100 an hour, and my hourly rate at that time, let's say, was $350, my client has to pay £250 an hour. That's not commercially attractive to my client. So what we did in this instance is we put forward representations to them in one telephone call where I pointed out to them, I've got standard letters here that I can send out to you, we'll report it to the Ombudsman, you've got to be paying a fair hourly charge out rate. Now, you may think, okay, well, that's all simple, all lawyers should know that. Unless you've been doing a lot of claimant work, you're not going to know. And if you're an employer, you need to be aware that employees do have potentially this funding in place. And so it may mean that you've got to take certain assertions, certain allegations more seriously. Now, we managed to obtain from there the insurance cover, and then 3 or 4 months later, managed to get a deal done. So that was on the basis that we had our detailed strategy in place. Now, we had another case, this is a case study 2, which was a sexual harassment claim against this guy. This chap was a chief executive officer. And what was interesting is that this chap had pointed out that in his bio had said that he's the life and soul of the party. Now that's very interesting, considering the allegations that we were raising against him. Now, the challenges and why we needed to front load this case was that we had about 8 or 10 allegations, some of them which were very salacious. Unfortunately, we couldn't use the more salacious ones because after taking detailed instructions from the client, it really showed that she'd consented to some messages that had been sent to her. And because we'd front-loaded this case and we'd taken detailed instructions, we knew that there was only 2 allegations that we could actually rely on. And that's what we did. Now, we had a 4-day window to settle that case because the client was going to move on to another job. So what we had to be was very firm in our negotiations, but at the same point reasonable in what we were asking for. In this instance, we didn't need funding because this case was wrapped up in 3 or 4 days. But how this is relevant to what we're looking at today is that we had to get a detailed strategy in place with tactics, knowing what the client's objectives were so that we can get to an outcome which resulted in about 7 or 8 months pay for her, and then she moves on. So that worked out for her. Now, this is a prime example, and it's a case that hasn't finished yet, of a situation where you've got to get your funding right from the start. This client came to us after he'd instructed a major law firm, another law firm, to litigate for him. Now, this lawyer had charged him already £70,000. Goes back to my point, you can be a very technically gifted lawyer, but you may not have the tools to bring parties to a table for the purposes of settlement. Now, within that 70,000, he hadn't picked up the phone once to the other side to negotiate a deal and hadn't given any assurances in terms of prospects. And in fact, 3 or 4 days before issuing of proceedings, he asked the client that he needed to have a war fund of £750,000 to litigate. Well, this is a £2 million potential exit. And the issues here are whether or not this company is going to pay fair value on shares it's got or purchase price. And from our perspective, it needs to be fair value. But what was relevant here was what we actually did. We took this case over, we tore it apart, and we committed to prospects. We committed to what case law would apply to him. We also did a number of things. We took it on a part contingency fee basis. So we would be paid X amount. If we got Y result, we'd get our normal hourly charge out rate. And if we got something above that, we'd get an uplift. Now, that made it very commercially attractive for the client because his risk exposure has now gone from an uncertain £750,000 to £250,000. On top of that, we've also agreed in principle after the event insurance. So if he has a cost order and if he loses, which he won't, potentially he will have those costs paid by the insurers as long as he pays his premium. Now, not only does that benefit the client in terms of where he stands in the litigation, but what it did do is it meant that we could go to the other side and when we said to them, look, the position is previously you didn't think our client was going to litigate and you never came to the negotiating table and you weren't interested. Now, we've taken this case on a part contingency fee agreement. We've got insurance-backed litigation support to fund this. Now, the fact that we've taken it on a contingency fee means that we are committed to this litigation, and as a result of that, they've now come to the table and we've got a mediation hearing next week, which will hopefully settle the case. So the outcome is, watch this space. Now, this was a case where we acted for an employer. And the challenge in this case, there was a number of challenges in this case. The employer was being sued, potentially, by his in-house solicitor. So she knew exactly the strengths and weaknesses. Also, when we considered the papers in detail, because the allegations were so specific, there was sort of a 50-page grievance that was submitted, the chances are what this individual was saying was true and potentially could establish that in any employment tribunal hearing. Now, again, in this instance, this individual hadn't followed my previous advice. He was the owner of the company and didn't have legal expense insurance. So if he'd had it, we'd have been in a different position, because potentially we could have at least set out some areas where she wasn't able to be successful and managed to do some form of negotiation for the insurers on that. We weren't able to in this case. Now, she asked for £150,000 initially. Now, I asked him, what is she going to expect you to do? He said, well, she's going to expect me to be very nervous in this whole case, pick up the phone and try and do a deal. So what we did the opposite. We drip-fed information. We ignored areas where she put forward allegations, and we ignored proposals for settlement at that stage. So didn't even entertain, didn't even indulge it. 6 weeks later, the case settled at £10,000 and potentially could have settled for even less had the client wanted to wait longer. So that's where, again, we provided advice, we got a strategy together, we committed, there weren't going to be issues on this, but the strategy worked out. In this instance, there was no contingency. Unfortunately, the only contingency would have been that we had to litigate. Now, this was a breach of contract claim and acting for a senior executive against a big Italian fashion house. Hugely successful, but slowly declining in terms of store sales. Now, again, this was a situation which was a lesson learned both for the employee and for the employer. The employee and the employer negotiated the contract themselves and negotiated provisions for their bonus. And this bonus payment was so badly drafted that it created litigation. And there were two things that my client didn't do, which he should have done. One, he didn't get legal expense insurance, which then made litigation pretty stressful for him. And secondly, he didn't consult lawyers on this bonus that he was to be paid, which meant that when he was made redundant 1 year into his employment, although he was entitled to the bonus, and that was something that the employers didn't understand, which created a lot of confusion, potentially he had to wait 3 years to be paid that bonus. Now, we weren't going anywhere on the negotiations. And the only time we got somewhere on the negotiations was, and this is again a milestone if you're negotiating, when there was a change of solicitor and when we notified the other side that we were taking this case now on a contingency fee basis, so we were fully committed to the litigation. Of course, we didn't let them know that potentially we'd have to wait 3 years to get paid, and that we negotiated for our clients after the event insurance. So he was covered in terms of any cost orders that would be made should he lose that case. Now, the fact that we gave that commitment brought them to the table, and in this instance, we managed to recover 90% of the damages and 50% of our legal fees, which was a very, very good outcome for him. Again, this could have all have been avoided if he had insurance in the first place, because after the event insurance can be expensive. Now, lessons learned. Even if you are an owner, manager of a business, get insurance under your home and contents policy. Even if it doesn't cover you for employment tribunal claims, because you may not need them, because you're not an employee, you're going to need it for something. If you're a senior exec, even in the business, get funding. We can help you on that. You can send me an email and I can check with your broker whether you've got that under your home and contents insurance. If you're instructing a lawyer, get that lawyer to commit. And don't allow the lawyer just to run with the case and hope for the best. Most lawyers don't do that, but there will be some lawyers who do. Press on advice, press on strategy, press on the implications of litigation. Also, always proceed on a case as if it were litigated. Don't proceed as if you're going to get a deal done in the next 2 or 3 days. Ensure also that the legal advisor shares some of the risk with you. There's plenty of good advisors out there who will do that, rather than asking you for £750,000 to litigate, which in my view is absurd. You can't commit any client to that. Also, ensure always as an individual that you have a contingency plan. Plan A may not work. Make sure you've got plan B. Lessons learned from the employer. Organise your litigation funding. If you're a certain size employer, you'd be surprised actually how cheap that litigation funding is, as long as you have all your ducks in a row in terms of your contracts of employment and your staff manual, and they've been ticked off. I can look at that for you. I can advise you. I can tick that off for any broker who then goes to the underwriters and gets that insurance for you. You do not want to be paying any lawyers £400 or £500 an hour to litigate. What I also do is I split advice between HR and the legal advisor. So if there's an issue on an employment-related matter for an employer, I will take the instructions initially. I will tear the case apart and commit on prospects and strategy. Then work with either the internal HR or an external HR who charges £100 an hour. They will then deal with any internal grievance or any internal disciplinary. And then, from there on, if it does have to litigate and we have to defend proceedings, there's insurance in place for me to then invoice the insurers. And then that becomes a commercially attractive deal for the employer, and also is sending a message out to employees. If you try and litigate and you haven't got a good claim, we will defend that claim. Also, train your employees. That's pretty basic. And also be aware of personal liability for unlimited discrimination and whistleblowing claims. So if any discrimination claims are made against you as an employer, if you also individually have discriminated, or there's an allegation that you have discriminated, your name will be put in those proceedings and you can have a personal liability. So you can't hide behind your employer on that. Now, do we have any questions? I thought if we go on for too long, for an hour, it could get sort of slightly boring for the parties. So I'm open for any questions right now. If there aren't any questions, you may want to email me and say no questions. I know how many parties have attended, so I can then switch off if there are no further questions. I'll wait for a few minutes because I don't know what the timing is if you send something over. I haven't had any responses. I'll wait another few more minutes and see whether we do get any questions. Okay, I've got a question here. Would I agree, should SOs ascertain their aims and objectives from the start? I presume that says the solicitor. Let me see how I can answer that question, because I don't understand it fully. The client should provide their aims and objectives from the start. So, as in an example that I gave with regards to the sexual harassment, we knew that we had a short window in terms of undertaking the negotiations. So really it should be up to the solicitor to ask, what are your aims? What are your objectives? And then base the strategy around that. But sometimes you need to let the client know also what the objectives have to be. Right, thank you very much. Yes, so from a legal perspective, thank you. Absolutely. From a legal perspective, the solicitor has to ascertain those. But you don't always follow what your client says. Sometimes you have to say, look, we can't work within that. We're not going to litigate at this stage. We need to do X, Y, Z. But that all needs to be set out in writing. That's the advantage of having a full-blown opinion. Everyone's committed. There's no misunderstanding on costs. There's no misunderstanding on what the solicitor thinks on prospects. There's no misunderstanding on what the objectives are. In the letter of advice, it should state, you inform me that your objectives were X, Y, Z. This is why we can follow these objectives. This is why we can't. So thank you very much for that question. Hopefully it answers it. Perfect. Thank you. Right. I will wait for... I've got another question with regards to managing expectations. It is always a good idea to manage clients' expectations, of course. And the point is, it may well be that sometimes with the clients, you won't be able to work together because your view is X, their view is Y, and that is exactly the time where they should go and seek an opinion from someone else. You don't want this happening 6 months later. You need to be honest with your client in terms of where you genuinely think they stand, whether you genuinely think they stand in terms of what they can achieve, and how you can get to that position. The worst that's happened, they've had an advice, the chances are they'll probably be given the same advice elsewhere. And there's nothing better than getting more money for a client. So always good idea to manage client expectations. And maybe that's something I should have emphasized more on the webinar. So hopefully that answers your question. If it doesn't, I'm more than happy to clarify. Okay, well, I've got a question here. Would you like to come and speak to our students at Staffordshire University? This has been a very informative webinar. Thank you, sir. What a compliment. Of course I would. That's something, it's something they can get, and I will give real life case examples. And then hopefully it'll be also better for me because I can actually see who I'm talking to. And I used to be on the panel at some universities. I've been on the panel for Birkbeck University talking about stress-related issues. So I would be more than happy to do that. Please email me and we can arrange that for the new year. I don't know if I've got any more questions. I'm just checking now. Let me see whether we can. Sorry, apologies. I'm just looking at the next question, if there is one. I can't see any questions. However, if for whatever reason that is my error, please could you email me your questions and I'll be more than happy to deal with them. Let me just see whether or not. Okay, I've got some more questions about attending the university in February. I would be more than happy to do so. It's on the 20th. And I'd be more than happy to do that. Bear with me. Apologies for this. I don't know what's happening. Right, so we've got... I can't see any more questions, and I'm being threatened with a power off. So please feel free. My email address is thalis_vlachos@gunnercooke.com, as it is on the screen. Please email me with any questions, and I'd be more than happy to answer them for you. Thank you very much. Thank you. A pleasure. Mr. Switch on.